I'd still urge this court to really look into my issues, because as we speak, my family is suffering, and I'm the only person who can access the content of the documents which are needed
by your family,
by my family, to contest.
There are documents that you hold that the family needs,
and I'm the only person who can access them. But
Where
when I'm behind bars.
Where are they? You have kept them at a safe location?
Yes, under what instructions? Under the instructions that I was given.
No, that's fine.
Yes.
But there are documents that you can access and hand them over to the family if you had the opportunity to do that.
Yes.
Mm-hmm. So that if the court were to give you an order for escort by these officers to that location, would you not be able to get the documents and help your family with them?
I would.
Sorry?
I would, my lord.
Uh-huh.
Yes. So, and this is because they all know that is the reason why I'm behind all this. Had I maybe given out that location
of where the documents are,
I would not be here today.
Sorry, you would not?
Had I given out, or had I disclosed to my uncle where those documents are, perhaps I wouldn't be here today. Because that was the genesis of all this. But I couldn't have done so because they were given to me under very strict instructions by my late father. So that is why I'm saying I am finding myself in between a rock and a hard place.
Okay. So that, if I understand you, what you're saying, if this court, short of releasing you, was to say, okay, Mr. Kihara, you have a right to life. That has not been taken away by the court. Okay?
Yes.
And part of realization of that, the fruits of being alive, is getting access to what is rightfully yours.
Yes.
So be escorted from point A to point B.
Yes.
That would satisfy what you are raising. You will be able to deal with the family issue outside these proceedings.
Partly it would, partly it wouldn't.
I'm not saying that that to mean that we are not looking at your application.
Okay.
I'm just looking at an interim measure, because you are saying you are holding on to things that the family may require.
Yes.
Yes, as you sit in prison.
Yes.
And that is part of your argument, that why this court should consider releasing you. And I'm saying, well, as we consider that, is there anything in the meantime that you think the court could be of help to you in terms of moving you from now here? You have been moved from Manyani to Nairobi.
Yes.
Right?
Yes.
These officers will take you from here probably back to Manyani or to Kamiti.
Yes.
And I see no reason why, if you disclosed to the officer in charge, where were you held last night?
At Manyani.
So you came in by night?
Yes.
Yeah. So that if the escort was to be limited to a specific location, you go retrieve whatever it is, then you, as you have this particular case?
In that particular case, it was also for robbery with violence, my lord.
This was in Nyeri in 2016?
Yes. And in that particular case, my lord, if you peruse on the prosecution's points of submission,
just a minute. You're saying what about this?
If you peruse on the prosecution's points of submission, I think at paragraph 16, 17, and 18,
Yeah.
thereabouts, you can see the manner in which that case was conducted. to a point that even the prosecution steered off. And they said that what was done by the trial court, the damages and the inconsistencies were beyond repair. And they left the court to make a decision. But I still ended up being convicted for 6 years.
So did you appeal against this one?
No.
To the Court of Appeal?
I didn't.
So you served the period?
Yes. And my lord, that was not the only case. Even the circumstances surrounding this
before
case.
we leave this one, because I also want us to be clear about a few things.
Yes.
I'm looking at what you're saying, the prosecution conceded to. And basically, from a reading of paragraph 16 and 17,
Yes.
the prosecution were barely conceding on procedural issues. And they never commented on the merit of your case.
Yes.
So that the point you are making about being framed never arose from the prosecution submissions. I don't know whether you've noted that.
Yes.
Because they're only talking about non-compliance with section 200, non-compliance with 169. Yeah, and those were basically the two. And then they said they considered the appeal, which the judge disagreed with, and you have said you never appealed. So if you did not appeal, then the court can really not delve into that.
I did not appeal.
Yes.
I made an application for custodial sentence.
To be considered also.
Yes, but I had, these cases came. I had the Nairobi case, I had the Nyeri case, all of them were going on. And just before the judge could grant me probation,
Which one now? The Nyeri one?
the Nyeri one, I was convicted by the Nairobi case, my lord. And
So the Nyeri one, just a minute. The allegation was that robbery happened on 30th of December 2013.
yes,
The Nairobi one, the one which is before me,
yes,
the allegation was that robbery was on 27th of April 2015.
yes,
And they involved different motor vehicles, different complainants altogether.
yes.
Okay? So you are now putting this to demonstrate what?
But the investigation officer was one.
In both cases.
In both cases, my lord. And even when, on the 27th of April, I was actually coming for a mention here in Milimani, under case number 621 of 2015.
You add yet another file.
Yet another file.
A robbery one.
No, that I had stolen women handbags at a club along Langata Road.
Okay.
And
And that one was pending in Milimani.
It was going on here at Milimani, and I was coming up for mention. And
So that is when you were arrested and charged with this robbery.
With this robbery, it wasn't the initial charge sheet wasn't about robbery.
Yeah, it was theft of motor vehicle. I
It
can
was
see.
possession of a suspected stolen motor. And my lord,
Yes.
I was out on bond on both cases. So when I came here, the IO, the same IO, he was in court, he was so ready to arrest me again.
Yeah, I've seen that in your affidavit.
Yes. And actually it is even in the proceedings of this case we are talking about now. And he claimed to have been contacted by a person, a manager from Equity Bank Nyeri, to come and arrest me. And that is when I told him that I had a motor vehicle parked at the judiciary parking yard. This motor vehicle now.
The one you're charged.
The one I'm charged with. My lord. So he arrested me, took me to Central Police Station, transferred me to Nyeri. So in fact, about this motor vehicle was not arrested. And it is on record, my lord, that, and I have even indicated that in my affidavit, that he summoned me by phone. And I have actually, let me just look at it. J on the affidavit, 14J, the IO said that I voluntarily responded to a phone call from him and presented myself at the police station.
Yes.
My lord, a guilty person would likely have fled. And the reason why he contacted me, it wasn't even about this motor vehicle, because when I raised those issues, they are on record.
Yeah, and that was all considered by the other courts.
Yes, it was.
Yes. And unfortunately, this court cannot properly, in exercise of its power,
Yes.
revisit issues of facts that have already been settled by the trial court,
Yes.
the High Court, and the Court of Appeal.
Yes.
I would be acting completely without jurisdiction to revisit those matters if they were matters of facts, unless you are dealing with a question of new evidence. And you say
Yes.
all the matters you are raising are matters that were within your knowledge during the trial,
Yes.
during the appeals, and these issues never arose. You see the predicament
Yes.
of what we are dealing with, and that's why I asked you again, and you said you are ready to prosecute the application as it is, which is basically for sentencing. And if you confine yourself to that, then, and of course I will look at all these issues that you have raised, I'll pronounce myself on each one of them and the effect they have on your application. Don't worry, because the material is before me. That is why I have this file before me, and I'll look at everything. Yeah, but make your point. So you are a victim of harassment and intimidation. That's what you said. And that's why you never spoke about this.
Yes.
Proceed.
And again, my lord,
Yeah.
I have really tried,
Yes.
and the advocate that I have indicated here, the issues that I had issues with, he's not the only one. And if you look at that file, I had several others. And this one is not the only one I feel that was compromised. And as you look at clause 6 of my affidavit.
The one again for October.
Yes. Clause 7. Clause 8. I have categorically indicated what transpired. And yes, I'm alive to the fact that I never raised these things up.
Sorry, you never?
I am alive to the fact that I never raised all these things during trial. And I have given out the reasons as to why I never talked or shared with the trial courts. So perhaps this court can guide me and help me and sympathize with me. Because, my lord, in matters of law, I have never been to a law class.
Don't worry, just a minute. You've heard what the prosecution counsel has said. And basically, I would summarize it this way. He says, one, all that you are saying now, these matters are purely an afterthought. Just something you have come up with to come and whip sympathy from this court so that the court looks at you with an eye of mercy and releases you. That is one. Two, he says this court has no jurisdiction to inquire into the questions that you are raising, which was the primary question. And I think that's basically what Mr. Mogeri has urged the court to do. But he agrees the period you stayed in custody before conviction and sentence, that can be taken into account.
My lord, I need to make some clarifications.
Yes.
So that the court can be in a better light.
What is this?
This is not something that has started now. He would have at least requested me to prove, because I have mentioned names and institutions way back, even in 2019, 2022, 2023, and the prisons are here. And the prisons are also, they do keep records. I have been trying to find ways of reconciliation.
With what?
With my uncle. people have been sent, even when he was the deputy president. We have text messages, WhatsApp from my family, trying to find a way for reconciliation.
Between you as a family?
Yes. People from his office have visited me several times. The prisons have their records. So I wish he could have at least maybe given me that time to maybe explain to the court. So it's not something that has started recently. And it is after I went to a point of even going overboard beyond family when it didn't bear fruit. And I started even using government officials, and I have mentioned.
The point Mr. Mogere is making is this. He says, all those things that you are saying are not new matters. These are things that you knew all along. But you did not raise them during your period of trial throughout the appeal. But you have now brought them at this point so that the court can be sympathetic to you and probably grant you a favorable order. That's basically what he's saying.
It's true. Yeah. I'm seeking for sympathy because I don't have any other place that I can go seek sympathy from. Also, number two, my lord, he never told us that when you're threatened, when you're arrested and taken to a police station and booked, when you very well know that you haven't committed any crime, yet you find yourself in a court of law and you're convicted. And then you are warned, you are threatened, you're intimidated. As a human being, what am I supposed to do? My lord, it got to a point even my people were abducted as ways of being threatened. What was I supposed to do? And when it comes to such a time, who should I go to? And I have indicated very well, the only time I gathered courage is when the government gave me assurance.
Yeah, and Mr. Mogere says there was no assurance or anything from the DPP, contrary to what you say about this matter.
My lord, I have attached their responses. When I wrote to them,
yes,
they responded.
Just a minute so that get to look at what the DPP said when you wrote to them as you answer Mr. Mogere. Just a second. Yeah, Office of the DPP, thank you for reaching out to the office. We have received your email and our team is currently reviewing it. Please note that we will respond to you as soon as possible. That was an email sent to you on the 8th of August 2025.
Yes.
Anything after that?
They never got back to me.
Okay.
And if you can check on this file, my lord, before Mr. Mogere came, we had another state council. And you had requested her to go and recheck this.
Yeah.
But they never did.
Okay.
And this, my lord, it was not only this, the office of the DPP, even the CJ acknowledged. The ombudsman gave my issue a ticket number. To a point, they even responded fully after they reviewed it. And they advised me to seek.
They advised you to seek what?
Services or guidance from the court because it was out of their mandate.
Ombudsman.
Yes. So the reason why I came to court is because the DPP, I knew I could find the prosecution.
Yeah, I can see what the ombudsman
but they never gave,
said.
they just said they're going to get
to either go through way of an appeal or review the court of appeal.
Yes. And but the DPP never got them back. They never gave me any.
That's fine. But at least the court was kind enough to tell you the proper forum to go is either you prefer an appeal or you go back to the court of appeal for a review. Did you go back to the court of appeal, by the way, by any chance?
For an appeal?
After they had given you their judgment, did you attempt going back there?
I did not.
Okay.
I did not go back there, my lord.
Yes.
Because this court has the original jurisdiction, and I have highlighted that.
I've heard that.
Yes.
Okay.
And even those other cases, my lord, there are some litany of authorities I have
Don't worry about the authorities. I'll look at them.
I have seen so many cases.
Yeah.
Even this court
Yeah.
has made decisions of cases which have gone to the Court of Appeal,
Yes.
gotten back to the High Court,
Yeah.
without any order from the Court of Appeal.
Yes.
And they have been listened to and determined. So I don't know why mine, or why the prosecution
Yes.
really insists that I must have an order from the Court of Appeal. Because
At least they have considered one thing.
Yes.
They have said on the time that you spend in custody before sentence, this court has jurisdiction to look into that if it was not factored in by all those courts. That one they have considered.
He has also raised an issue.
Yes.
There's an issue he has raised.
Yes.
That can I just read it out for you?
Yeah, fine. Just read out.
That the prescribed punishment for this offense remains death, and there has been no change in the prescribed punishment between the time the offense was committed and the time of sentencing.
Yes.
The Supreme Court's decision in Francis Kariuki Murwateto in another versus the Republic 2017
Yes.
declared the mandatory nature of the death sentence unconstitutional,
Yeah.
but did not abolish the death sentence as a prescribed punishment.
Yes.
My lord,
Yeah.
I beg to differ
With what? With that particular position?
with this particular position.
What is your
Because-
thinking about death sentence?
Because, my lord, initially, the hands of the magistrates were tied.
Yes.
It was purely death sentence.
Yeah.
So when you come and tell this court that it did not change, it's misleading the court because
Now the point he's making is this:
yes,
death sentence is still a valid and legal sentence. That is
but
what
not,
he's saying.
but not the
But not mandatory. It is not the only sentence. That's what he's saying.
so the court has a leeway to
Yes,
decide
the
on.
court has discretion.
But in
over
my
that.
issue, he says
Yes.
by the time
Yeah.
I was being convicted
Yes.
and during trial,
No.
this had not happened.
You know why that should not worry you?
Yes.
You are not serving a death sentence to
Yes,
begin
I'm not.
with.
Yes.
So that question is not even relevant to the proceedings we are dealing with. Because if we were dealing with a death sentence that was imposed against you, then you would have reason to worry about what the state is saying about death sentence that matters such as those. So that should not really concern you.
Okay.
Yeah.
So he also said robbery is a serious issue and
Yes.
a serious case.
Yeah.
But I also feel the aggravating factors also should be considered. And in this case, I read out a paragraph where the learned magistrate said
Yeah.
there was no harm. And in fact, the witness or the complainant gave contradictory statements.
So if there was no harm, Mr. Kihara, and the court gave you a sentence of 20 years instead of death
Yes.
sentence, don't you think then they applied the Murwatetu, the one you've just been referring to, they actually applied the principles behind it, that where the sentence provided for is death, you can exercise discretion and impose a lesser sentence considering all those factors, aggravating nature of the injuries, if at all, or the circumstances of the case. You don't think the court was fair by giving you 20 years?
I feel it wasn't fair
Okay.
because there are other very serious cases that I have highlighted here in the form of authorities. So I beg the court to look at them.
Okay.
Yeah. And come into
That's it?
determination. Yes.
The officer in charge, Manyani Maximum Security Prison, is hereby directed to assist the applicant by temporarily removing him to the location the applicant says as his family documents kept for him to retrieve the documents and hand them over to the family for their use. And you were saying they require the documents?
Yes, to file a petition for the family division.
For their use in any intended legal process. Sasa, that is clear.
Yes.
So, ni kumtoa, kumfikisha achukue documents, then you take him back as you await the ruling. Okay?
Clear, my lord.
That's fine.
My lord, when did you say the ruling is?
I gave you the 17th of June.
Okay, thank you.
Si hapo utasaidika kwa kupeleka uchukua documents, eh?
Yes, my lord.
Okay. So I have decided not to put that here so that it doesn't fall in the hands of wrong people, as you said.
Yes.
Give the officer in charge the location.
Okay.
Then he will exercise his power and remove you to that location. Okay?
Thank you, my lord.
Thank you. That's all?
Yes, Judge. I return this or file it.
I think I will need to look at it.
Okay.
Do you require this judgment or I can keep it in the file?
You can keep it, my lord.
Okay, thank you. So the court will now adjourn.